Welcome to the Australian Law Reform Commission podcast. Hello and welcome to the next episode in the Australian Law Reform Commission's podcast series, where we're talking about corporate criminal responsibility in Australia. I'm Nadine Davidson-Wall, Communications Coordinator at the Alrc, and I'm joined by Tess van Geelen, a legal officer at the Alrc. In the recent corporate crime inquiry, Tess looked into the regulation of transnational crime and some of the ways that Australian companies can be held responsible for their involvement in offshore human rights violations. Tess, can you walk us through the background to this issue and how it fits into the corporate crime inquiry?
Thanks, Nadine. So this aspect of the inquiry arose out of the terms of reference that we received from the Attorney General, which specifically asked the ALRC to consider the potential application of the Commonwealth Criminal Code to extraterritorial offences by corporations. So under the code, a number of offences already apply extraterritorially to some degree, and this means that if an Australian company engages in conduct like slavery, human trafficking, tax evasion, or financing of terrorism in other countries, they can still be prosecuted for it here under Australian law.
So how much of a problem is this among Australian companies operating overseas?
So as we know, globalisation has really opened up international trade in the past century, and Australian companies are now connected to supply chains that spread over multiple jurisdictions all over the world. While most people would agree that businesses are fairly heavily regulated in Australia, that's not necessarily the case in a lot of other countries. Part of the motivation for companies moving their sourcing and manufacturing offshore is access to cheaper prices for labour and resources, which unfortunately is often closely tied to weaker protections in those jurisdictions. So while those cheaper operating costs have translated into huge savings for Australian consumers, over the years there's been a fairly steady stream of reports from civil society, governments and the UN documenting alleged cases of Australian companies engaging in misconduct overseas. These allegations have ranged from things like child labour and slavery to environmental destruction or forced evictions of communities to make way for mining developments, for example. As I mentioned, a lot of this conduct is already criminalised in Australia, even when it happens overseas. But in the course of our inquiry, we found almost no examples of Australian companies that had been successfully prosecuted for this kind of conduct. So given how widespread it seems to be in the global economy, this suggests to us that the criminal offences we have in place are just not very effective at preventing this type of abuse.
So what did the ALRC ultimately recommend to address these issues?
Given the wide scope of the reference we received, we had to think carefully about how to tackle this aspect. And a lot of people working in this area would agree that you could run an entire inquiry into this issue alone. One of the challenges we ran into quickly was the realisation that while criminal law has an important role here, it also has some serious limitations. In light of that, we ended up responding in two parts. In the first, we recommend amendments to the criminal law to improve its capacity to prevent transnational crime. And in the second, we suggest that the government undertake a much broader inquiry that can look into other non-criminal regulatory options and how they might complement the criminal law in this space.
So let's look at the first part. What changes did the ALRC recommend for the criminal law?
We recommended that the government consider introducing a failure to prevent type offence for certain existing extraterritorial offences, modelled on the failure to prevent foreign bribery offence that's currently before Parliament. So under this model, a corporation can be held liable for failing to prevent certain misconduct by associates acting on its behalf. Associate is defined to include people like employees, agents, or wholly owned subsidiaries.
So how would that make the criminal law more effective in this space?
So one of the major barriers here is that the criminal law has particularly high evidentiary standards that are really difficult or impossible to meet when the relevant conduct happened overseas. These standards are designed to protect the liberty of individuals being prosecuted by the state. But in the case of multinational corporations, the balance of power is very different, and these standards seem to skew too far in limiting the effectiveness of criminal regulation. Under the failure to prevent offence, if an associate of an Australian corporation has engaged in something like slavery overseas, then the corporation will be deemed liable. So you no longer have to prove that the corporation itself also intended to engage in slavery.
So following on from that, what can a company do to ensure it isn't liable then?
So a corporation will have a defence if it can prove that it had in place reasonable measures designed to prevent that type of misconduct by its associates. The defence encourages companies to take proactive responsibility for the actions of their associates and the particular risks created by their activities. On the other hand, if they have reasonable compliance procedures in place and a rogue employee disregards all those rules to engage in misconduct anyway, then the company won't be liable for that.
Okay, so then can you tell us a little bit more about the second part of the ALRC's recommendations on transnational crime?
Yeah, so as I mentioned, we found that the criminal law can be quite limited in responding to the full spectrum of misconduct that corporations might engage in overseas. So while things like slavery and trafficking are criminalised, global supply chains can have a huge variety of harmful impacts on people and communities. And the company at the end of the chain in Australia may have different levels of knowledge, involvement, or influence over those practices. We naturally want to minimise the incidence of human rights violations in the production of goods and services entering the Australian market, but since the criminal law has such a high evidentiary standard, the vast majority of this harm currently doesn't fall within the scope of criminal regulation in practice.
So if misconduct is not addressed by criminal regulation, are there other non-criminal forms of regulation that can be used?
Yeah, so in the last couple of decades in particular, we've seen a lot of progress both at the international and the domestic level in developing new ways of dealing with the human rights impacts of multinational businesses. So in Chapter 10 of the final report, the ALRC outlines a number of non-criminal regulatory mechanisms. These are things like due diligence obligations, transparency regimes, or non-judicial dispute resolution forums.
What about the new Modern Slavery Act that was introduced a few years ago? Why isn't this enough to solve the problem?
So the Modern Slavery Act was certainly a step in the right direction, but it wasn't particularly ambitious legislation. It doesn't actually require corporations to do anything about modern slavery in their supply chains. It only asks them to report on any risks that they're aware of, but even if they fail to report altogether, there are no penalties. So the Act is also really limited in scope in that it only looks at slavery. But as I mentioned earlier, there are a huge variety of ways that businesses can impact on communities and ecosystems apart from slavery. The Act might help businesses to get used to the idea of thinking about human rights, but the government should ultimately undertake a much broader review and think about which of these other mechanisms we can implement to make sure that corporations that profit from abuse are held accountable for that. Of course, there's already been a huge amount of work done in this space by Australian civil society, and interest from government has ebbed and flowed over the years. So what we tried to do in Chapter 10 of the report was highlight all the work that had been done so far and bring it together into a clear, simple roadmap for the government indicating what the next steps should be. It's important that we don't think that it was all wrapped up with the Modern Slavery Act. There's still a lot of work to do in this space, and we hope this roadmap will help to move us a bit further along that path.
Thanks for walking us through the transnational crime landscape and the ALRC's recommendations.
My pleasure.
Thanks for joining us for this podcast series. This is the final episode in the series on corporate crime, but there is much more information into the reasoning behind the ALRC's recommendations in this inquiry. You can download the final report from our website, or if you're short on time, the summary report will provide a concise view. You can also comment on Twitter and LinkedIn, so head on over to our website to find out more, alrc.gov.au.